Get ready for the dictations at the rate of 80 words per minute. Dictation passage link is in description box. Get ready. 1, 2, 3, start. The petitioners have filed these writ petitions to quash the impugned show cause notices without appearing for the personal appearance and without submitting their explanation. The main plank of the contentions of the petitioners is that the first respondent government is not the competent authority to issue the impugned show cause notices. According to the petitioners, the district collector is the competent authority to adjudicate the issue as to whether the petitioners failed to undertake mining operations for a period of 2 years after the execution of lease deed, and thereby the lease shall lapse. Thereafter, if the decision of the district collector is an adverse one, the petitioners have an appellate remedy before the appellate authority. Hence, the first respondent is not the appropriate and competent authority to issue impugned show cause notices making the allegations contained therein. The petitioners also stated that while the show cause notices relied on the reports of the inspection teams that inspected the quarry sites, the same were not furnished. The impugned show cause notices also referred to the reports of the district collector, that is based on the reports of the inspection teams. The reports of the district collector were also not furnished to them. Moreover, the impugned show cause notices also refer to the letters of the Commissioner of Geology and Mining, and the same were also not furnished. Hence, according to the petitioners, the impugned show cause notices have to be interfered with. The petitioners also stated that the inspection teams made surprise inspections without putting them on notice, and the petitioners were not present at the time of inspection, and the show cause notices based on such inspection reports are bad and illegal. The petitioners also pleaded that the impugned show cause notices predetermined the issue, that the petitioners violated Section 4A(4) of the Act, and the show cause notices are merely empty formality. With these writ petitions were posed for admission in the motion list, this court heard the learned senior counsel for the petitioners as well as the learned special government pleader for the respondents and reserved orders. The learned senior counsel for the petitioners made the following submissions. The respondent number 1 has no jurisdiction to issue impugned show cause notices under section 4A(4) of the Act, and on the other hand, it is only the district collector who can adjudicate the issue, and thereafter there is an appeal remedy. The following decisions are relied on in this regard for the proposition that if the statute prescribes an authority to decide a particular issue, only that particular authority shall decide the same and not some other authority or higher authorities. Kumaran versus Karnataka State Road Transport Authority 1986 1 SCC 357 para 15, and Manohar versus Unnikrishnan 2012 11 SCC 437 para 23. As a corollary, it was submitted that when the statute mandates the things to be done in a particular way, those things should be done in that manner alone. Hence, instead of the district collector issuing notice, the notice issued by the government is contrary to the mandate of the law. It was submitted that while the show cause notices rely on the ex parte inspection reports, the reports of the district collector based on those inspection reports, and also the letters of the Commissioner of Geology and Mining endorsing the reports of the district collector, the said reports are not enclosed along with the show cause notices, and those reports are vital documents, and therefore in view of non-furnishing of those relevant documents, the show cause notices are liable to be interfered with. It was further submitted that the inspection reports were ex parte reports and no notices were given before conducting the inspection on the quarry sites, and therefore the show cause notices based on those reports are bad and illegal. Lastly, it was submitted that the first respondent predetermined the issue, that the petitioners violated Section 4A of the Act. They relied on the following judgments in this regard. Siemens Limited versus State of Maharashtra, reported in 2011 24, SEC 44, and VSO Balamurugan versus District Collector reported in 2012. On the other hand, the learned special government pleader submitted that several complaints have been received by the government on the illegal granite operations in Mellur Taluk in Madurai district, and on receiving a direction from the government, the then district collector conducted an inspection and submitted a preliminary report that illegal quarrying has caused loss to the government over an extent of 16,000 crore. Thereafter, the government have instructed the district collector to take appropriate action in accordance with law. Stop.